Vergouwen's work had Sleven the Toba Bataks, here presented in an English translation, was published in the autumn of 1933, a few weeks before the author's death at the early age of 44 from tuberculosis, from which he had suffered since 1930. During the time he spent in a sanatorium in Davos and later Netherlands, he began and completed his monograph and the customary law of the Toba Batak. His work immediately became one of the outstanding work of Dutch scholarship of Indonesian customary law, adat law. Jacob Cornelis Vergouwen began his career as an administrative officer in Borneo, now Kalimantan, in 1913 after a brief practical training. In 1921, he was given the opportunity for further study at University of Leiden, where a 5-year scientific training for a career as an administrative officer in the Dutch East Indies has just been instituted. On obtaining his master's degree, he was appointed to the Tapanuli Regency, from of all the hamlet of the Toba, Mandaling, Angkola, Deri, Batak. As a young official, Vergouwen has already evinced great interest in the laws and customs of the Dayak people in Borneo. His studies at the university brought him into close contact with the founder of the science of Indonesian adat law, Professor Cornelis van Vollenhoven, one of the greatest Dutch jurists in this century. Since 1901, van Vollenhoven had been teaching. Among other things, Since 1901, van Vollenhoven had been teaching, among other things, Indonesian adat law at the University of Leiden. For his research, he divided the Dutch East Indies into 19 law areas, Rechtskringen, based on the existing diversity in the laws and customs of the peoples in the various parts of Indonesia. By 1918, he had completed the first scholarly description of the unwritten customary law in the 19 homeonomic groups. He found his material for it by laboriously searching through the anthropological literature of the time, in the accounts of travels, in official reports, in the communications of Protestant and Roman Catholic missionaries, and in other judgments at the time only published sporadically. It was a masterly work, scholarly pioneer in the true sense. Van Vollenhoven worked out a fixed specific taxonomy and introduced special terms for the qualification of the legal facts and the legal concepts appropriate to the nature and content of the unwritten Indonesian law. He broke away from the attempts to squeeze this law into the straitjacket of the legal taxonomy and legal terms current in Dutch court law. Its other meaning index suitably to this Western legal system with an adequate taxonomy, with a legal terminology of its own and a specific approach. The science of adat law came to be acknowledged as a young tree, standing on its own in the park of Dutch legal science, a yet small worrying amidst, and beside the oaks and elms the study of Western law in the Netherlands. Van Vollenhoven gave all his great gifts of mind and heart in the service of the study of Indonesian adat law. An inspiration and a desire to study the laws and customs of Indonesian ethnic groups flowed from him to his students, with whom he remained in constant contact after they had begun their duties as judge or administrative officer in the Dutch East Indies. Van Vollenhoven has had a great influence on the striking development in the study of Indonesian adat law. During his entire scholarly career, he died in 1933 when he was nearly 59. He strove for the recognition and the just appreciation of this autochthonous Indonesian law, both in the administration of justice and the management of internal affairs. In 1909, he wrote his booklet with the significant title Miskenningen van het adat recht, four cases of lack of acknowledgement of adat law, and in 1919, the Indonesia and Zin Grond, the Indonesian and his land, in which, with a number of arguments drawn from scholarship and practical experience, he took a stand against government plans in respect of land rights because he saw them as a violation of the autochthonous legal system of the Indonesian people. In the splendid article Juridis Convecti Work and this privat recht for Indi ready-made legislation, a uniform civil code for the Indies, written in 1925, exposed the artificiality, the unrealistic nature, and the practical inapplicability of a proposed uniform civil code with a Dutch trademark, which was intended for all groups of peoples in the Dutch East Indies, Dutch, Chinese, Arabs, Indians, etc., as well as for the Indonesians from all parts of the large then diversified archipelago. This bill thereupon disappeared silently under the table. The point of view enunciated with such fervor by Van Vollenhoven and his supporters that, for the sake of justice, customary law should be acknowledged as being of at least the same ideal and practical value for the Indonesians and their social relationships as Western law is for the people in Western society, had by this time found a response among the highest policy-making government authorities. A half-hearted taking into account of the autochthonous Indonesian law changed into a positive appraisal. As early as 1924, a law university was established in Batavia, now Jakarta, where B. Ter one of the Vollenhoven's outstanding students, started to teach adat law, which he continued to do until 1939. In 1928, a commission was appointed with the object of advising the government on the principles of agrarian legislation in the Dutch East Indies, and adat law juries were freed to do research in various law areas. Another important feature of this new attitude towards adat law was that an investigation was ordered into the administration of justice in adat law cases, the aim being to effect a new and better regulation thereof. A pilot study was deemed necessary for that purpose, and this brings us, after perhaps over long discussion, back to Vergouwen and his work. May 1927, Vergouwen was relieved of his usual administrative duties and charged with the leadership of the highest customary courts, the so-called Rapat Nabolon, literally great courts, in the Toba Batak country, which at the same time instructions to embody his findings in the report and to make recommendations for reforms in the existing judicial organization. This report appeared in 1930, CP1 Note 1. On its completion, Vergouwen went on leave to the Netherlands, where he started on his own initiative the writing of his book, The Headresleven, the Toba-Bataks. Then he completed this work in spite of his lingering and vital illness, demonstrates his greatness interest in Toba-Batak society, his laws and customs, an interest which did not restrain him from making some rather critical observations in respect of particular facets of the culture of Toba Batak and the conceptions of right and wrong. In my opinion, he had a right to do so by virtue of his knowledge of the jugal relationships and the disputes daily brought before him as president of the courts, and his social intercourse with all levels of the society. He was no outsider dependent upon performance and inquiries. He had played an important part in deciding disputes and lawsuits of all kinds. In a review of Vergouwen's book, Den Haar says, Headresleven the Toba-Bataks is truly a fine book. The indigenous society and its many sided and complex relationships are studied and described from the design customary law is sought as a pattern running through the entire social fabric. This was I really endorsed. I still remember clearly how much help this book was to me when I was a student of adat law in Leiden from 1931 to 34, endeavoring to grasp the interrelationship of the Toba Batak legal facts. And even while I recall how in 1935 as a young government official, I had immediately on arrival in the Toba in Batak country the feeling that I had entered a known and understandable world. Above all, Vergouwen study was a source difficult to surpass, from which I acquired the knowledge and comprehension of Toba Batak laws and customs when I was president of the highest customary court in 1940 and 1941. It made it possible for me to discuss with the chiefs as members of the court on the footing of equality, as it were, the value and the meaning of the varying statements of the parties and witnesses, and after that, establish in collaboration with them the rule to be applied to the case before the court. Vergouwen's exposition moreover saw the way to those relationships when an conciliation or a military settlement could lead to a result satisfactory to both parties in the mutual relationships. The non-Batak president could collaborate from inside of the judicial findings, and what was also very important, could play his part in the development of the law by way of the administration of justice under changing social conditions which modify concepts of right and wrong in social and economic life. In my opinion, rightly, Vergouwen has described Toba Batak adat law in its flexibility within the framework of the social structure and forms of organization is based on kinship and continuity in village, territory, and in the wider groupings. It seems to me that for this reason his book is not out of date and will not easily become out of date either, whatever changes may have taken place since 1930 in Indonesia in general and in the Toba Batak country in particular. Vergouwen gives no hard and fast code rules which, as such, must be upheld when they no longer correspond to the social reality. New situations and conditions can only be understood against the background of all the recent cultural and socio-economic history. On this point, one finds in Vergouwen the necessary data and the context. Naturally, his explanations of the principles and the forms of expression of particular Batak institutions are not always the only ones possible. Here and there, he may lay too much stress on the magical religious element. Vergouwen did his research and wrote his book upwards of 30 years ago, and he was moreover not an anthropologist by profession. But it seems to me that this does not alter the fact that from his book one can become acquainted with the Toba Batak people and understand their social judicial life in their chronic perspective. This establishes the value of this book for the present day. Dutch cultural anthropologists esteem highly Henrik Sleven the Toba Bataks. In it, they have found much important material for theoretical studies in the field of kinship and affinal relationships in a patrilineal society with an asymmetrical connovium. I am pleased that funds have been made available for the translation of Vergouwen's book into English. One of the best Dutch works on Indonesian adat law can now be made accessible to the international world of students of social anthropology and customary law. The translation of a scholarly work of this nature is always hazardous undertaking, particularly when the author can neither supervise it nor influence it. In translating Vergouwen's book into English, a number of problems presented themselves. He wrote in a rather old-fashioned style of Dutch, in which long sentences, built up of subordinate clauses which were meant to explain the main theme, were effective. These have been broken down for the sake of readability. He also refers to government measures on plans for reforms which are not relevant to the present day, and I have taken the liberty of either deleting these passages from the translation or in some cases I have given a shortened version, but these minor alterations apart, Vergouwen's discussion has not been altered. The present translation is his book in substance and in spirit, and the translator in reproducing the essentials and the depth of his work has succeeded, in my view, in achieving as far as such is possible in the translation conformity with the style in which the original is written. Such minor, or perhaps major, error in the English syntax must be attributed to the minor alterations in the final draft. For this, I accept responsibility. J. Koning, University of Leiden.